put it on the, try to do it at another meeting. So I'm fine if we do that, but somehow we need to move, it's where it lands on the agenda. So maybe if you can just remind me, and I could even bring it up the next time it's way down the agenda, maybe to move it up.
Well, if you want to, so happy to continue. Okay. As the interim town manager said, I'm ready to go. We can do this. Mindful that the next meeting is not for quite some time.
Right.
So it will be another, quite significant delay if we wait. So I'm ready to go.
Right.
If you continue this item, you could give direction to staff to make this a particular agenda item in the next meeting, like make sure this goes first or second.
Right.
If that's the direction. So whatever the council's pleasure is.
Okay, Vice Mayor.
My worry is that our next meeting is going to be a little bit a bigger presentation on the housing, and I know that one we want to have enough people in the audience as well, so that one wants to be at the top of the agenda as well. So I'm not sure how many other items will be on that agenda since we won't have met for 3 or 4 weeks.
I would anticipate it'll be a full agenda since you're not meeting for your next 2 meetings. So we can do it now.
Well, it seems like most people do refer back to the videos and the agendas, so it seems like we should do it now.
I'm happy to highlight it in the newsletter that will go out tomorrow as well and continue to share the presentation.
And also, haven't we gotten Public Record Request Act on this topic?
Exactly, yes.
Just
let's do it.
Yep. Quite a few, actually.
Numerous topics.
Yeah.
Okay. So, want to keep going?
Yep.
All right.
Okay.
Let's do it.
All right.
Okay. The intro slide, that's good. All right. So let's jump right in. Public contracting is very different than private contracting. I think this is important to note as the very first thing in this presentation. The way the town contracts for things is very different than how you contract for things in your private life. Folks who are not familiar with public contracting might be thinking about the types of contracts that they enter into and how they do it, and applying those same concepts to what the town does for the town's contracts. These are not the same. Applying principles of private contracting to public contracting, it's apples and oranges. It might not even be two fruits, right? These are different things. And I'm going to go through what these different procedures are for the different types of contracts in a hope of clarifying some of the processes here, because there have been some repeat questions. There have been more than a few repeat questions. There have also been accusations that the town has not followed contracting laws or has not followed proper contracting laws. That is not the case. And so I'm going to go through what we actually do and how it's done to hopefully clear up some misconceptions about how the town contracts and how the town has contracted recently, which has come into some questions. There are very prescribed processes. So state law has prescribed processes of what we have to follow and how we do it. And the Yountville Municipal Code also has prescribed processes for what we do. It depends on what the town is contracting for. So the very first question that staff asks is, what are we contracting for? Once you answer that question, you follow a set of different processes for the different types of things, which we'll go into detail here in a moment. Contracting lives with the different departments. All of it flows through the town manager, and some of it comes to the town council. The town council has delegated some authority to staff. But public works contracts, those are handled by the public works department. Planning and consultant services related to planning, those are handled by the planning department. Administration handles other types of contracts. The clerk does as well. The town manager is involved in all of this, which we'll talk about in a moment. Generally speaking, there are three different types of contracts that the town might enter into. Supplies and equipment. So if you're buying a new desk or a new chair or a truck for the public works department, or any of the other tangible things you might need, that can include pencils for town hall. Services, so you are hiring some outside person to provide a service. Those services can be general or they can be professional and special. They're very different processes depending on whether it's a general service or a professional and a special service. And then finally, there are public works, sometimes referred to as public projects, but those are the same thing. And that's when you are constructing something or demolishing something, a facility. So think about a road or a water pipe or a sewer pipe or a building, for example. And the town's process here is in line and in some cases lockstep with other cities. That's because state law applies to all cities, and so we all follow a similar process. So this is not a unique process. The town did not come up with something on its own and put it into its code. We follow what the state law requires us to do, and that is reflected in the code to specify who has authority to do what. That's what the code is about. Next slide. All right. We're going to talk about some statutes. I won't read them all to you. I will give you a general description. They're here if you want to read the statute. There is a law that says every city and town and county, for that matter, and special district, those are all the types of local governments, have to adopt procedures for how they purchase supplies and equipment. And remember now, we're not talking about services. We're not talking about public works. This applies to supplies and equipment. So when you are going to buy tangible things that you need to run the town. These have to include competitive bidding requirements, and you need a policy, procedure, and regulation. For the town, these have to be adopted by ordinance. Other types of local governments can adopt a resolution. Some special districts don't have the authority to adopt ordinances, for example, and so they might adopt a resolution. But the town has to do it by ordinance, and this is why it's in your municipal code. The state law says it has to be in your municipal code. Next slide. The policies and procedures are by ordinance. Yountville Municipal Code 3.32.100 and following is where all of your contracting procedures live. If anybody's interested in looking what the town does, go and look in the municipal code. Those sections lay it out. So what is a supply? Office supplies, janitorial, materials, goods, tools, other commodities used for the conduct of the town's business. Except for supplies for a public work. That's because public works are very different. They follow a different process. Equipment, furnishings, machinery, vehicles, rolling stock, personal property. Next slide. So policies that apply to supplies and equipment. There is bidding, formal and informal. So depending on the dollar amount at issue, you either solicit 3 proposals or you actually use a competitive bidding process. So once staff determines we are contracting for supplies and equipment, they then have to figure out what is the approximate cost of this to decide if they're going to use informal bidding or formal bidding. There's cooperative purchasing. This is sometimes referred to as piggybacking. If another agency has already gone through a public process for the procurement of that supplier equipment, the town can directly purchase from that supplier under the same terms that the other agency has already competitively bid it. And the most common example of this is the state clearinghouse. The state enters into competitive contracts for the state fleet for trucks or fire trucks or police cars or any of the other things that the state frequently buys. And local agencies can then go to the supplier and purchase on those same terms, and that's referred to as piggybacking. Piggybacking only applies to supplies and equipment general. It does not apply to public works. Can't piggyback a public works project or for services either. There's sole source contracting. There is a lot of misconception about what sole source contracting is. So I think it's worth pausing here for a moment. Some people think that sole source contracting is where you just go out and select a provider. That is incorrect. Sole source contracting is when there is only one provider of the supplier equipment. So let's say, and this sometimes occurs in public works, you have your wastewater treatment plant and there is a particular machinery that has a piece of the machinery or a device that is only provided by one supplier.
Like our fuzzy filter on the wastewater treatment
That's right.
plant.
Exactly. So when there is truly only one provider, The town does not have to go through a competitive process. There's only one person who provides this, and you need it, so you can go out and purchase it. That is different than just going out and selecting someone following a different process. So that concept is often confused, but it only applies when there's only one provider, and frankly, that doesn't happen very often. Emergency contracting, the town, in the case of an emergency, can go out and contract. So if something, a sudden unexpected occurrence, pipe bursts or something, a true emergency that threatens public health, you can go out and contract. The town manager approves contracts up to and including $45,000. The town council approves contracts and amendments above that amount. And that's going to be true for other types of services too. Yep, go ahead.
Just really quick, so on the bidding, formal and informal, because this came up once before when I asked about going out to get different options.
Mm-hmm.
Could you just describe when it's allowed to be informal and when it's supposed to be formal? Is that, I probably should have read the ordinance, but I haven't. Is that a policy thing or a ordinance thing? And how does that work?
It's an ordinance thing. Okay. And purchases of supplies, equipment, and general services greater than $5,000, but not exceeding 25 is made by purchase order. Okay. And then amounts above 5 to 10 are bids and quotes, and then 10 to 25 under certain circumstances as well need to go through informal. So it looks like informal is up to 25,000.
So over that would require, if somebody wanted to look at the file, there would be quotes in there or different proposals.
Yes, unless another procedure or exception applied, yes. And then formal bidding is for anything over 45,000. And that's just for supplies and equipment here. Yeah, so when we're talking about services, that's special service. That's a whole different process, which we'll get to in a moment. Next slide, please. So services, these are either general or professional or special. Different processes for each of these. So when the town is contracting for services, the first question is this a general service or is this a professional or special service? Next slide. General service, anything such as janitorial, uniform cleaning, maintenance work, other services that do not require any unique skill, special background, or training. Obtaining these services at the lowest cost is the single most important factor. So if it falls under general services, we are trying to find the lowest cost to the town. General services are subject to the same policies and procedures as supplies and equipment. So we follow the same process for general services as we do for supplies and equipment. Next slide.
May I ask just a brief question? I didn't see like painters or asbestos removal people. Are they in the general services or are they more specialty?
Perhaps not for asbestos, but maybe for painting, right? Because if there are lots of providers and it doesn't require a special certification or a special skill, then perhaps, right? I would hold out the possibility that there's a very specialized painting job that might fall under the special services piece.
Okay,
but
so that's a little gray.
Yeah, but we would you look at it and look at the definition, and staff is constantly thinking about, does it fall into this category or does it fall into this category? Yeah. So professional or special services, any work performed by an attorney, doctor, architect, engineer, land surveyor, construction manager, appraiser, expert, accounting firm, planning consultant, computer services, or other services that require special performance criteria, specific experience, training, personal judgment, and quality of work, where lowest cost is not the sole factor to the town. So the state law that talks about this, which is in a future slide here, requires that the town not solely consider costs. And the reason for that is you are hiring a professional to do a specific job, and their experience and their qualifications matter. And you want someone who can come in and provide the best services for what you are looking for. And if you were required to hire the cheapest architect every time, you might not get the product that you want, and so on for the different services. So cost is not the sole factor here for special services, and that's a requirement from state law that's mirrored here in your municipal code as well. These are very different procedures here than what we've talked about for supplies, equipment, and general services. Next slide. So when we're talking about professional and special services, there are a few state law statutes that apply here. This is one of them. It says the town council may contract with any specially trained and experienced person, firm, or corporation for special services and advice, financial, economic, accounting, engineering, legal, or administrative matters, and it may pay these experts what it deems proper. That's all it says. Next section. Next slide. So here's another iteration of the same law. This one applies to special districts and counties and a few others. That one that I just talked about was only applicable to the town. But this one also applies to the town, and it says the same thing, right? You can go out and contract with these folks, and you can pay them what you deem proper. Next slide. All right, I'm not going to read this whole statute. You all can sit down and read this when you like, but I will give you the Cliff Notes.
The font is getting smaller.
Yeah, well, I had to fit the whole thing on one slide, and so I was, but I promise there aren't any more at this size. So this is referring to professional and special services for architects, landscape architects, engineering, environmental, land surveying, construction project management firms. So think about the recent contracts that involved a construction project management firm. There were some under contract over the last year or so. Certainly architects were hired recently, and there have been questions about those. These are the rules that we're following here, right? You have to go out and consider their qualifications, their past history, their correct fit for the project that you're hiring, and cost is not the sole factor, right? You should consider cost, and the town does go out and consider cost. But the state law and the municipal code do not require that you select the lowest bidder like you have to in other circumstances. And there's reason for that. For I mentioned, you want someone who's going to be a good fit and will do a good job for you, and not necessarily based on the price piece of that. You do have to prohibit practices which might result in unlawful activity, including but not limited to rebates, kickbacks, or other unlawful consideration. Bribery, of course, is a crime. And you all are subject to the Political Reform Act, just like many of the staff are here, which means that if you have a financial relationship with the firm that the town is contracting with, you have to recuse yourself from that decision completely. So that's what this is referring to here. It references the Political Reform Act there in section 87-100 of the Government Code. Next slide. Right, so this is just more on that. Government Code 87-100, this is part of the Political Reform Act. It prohibits you from participating in decisions in which you have a financial interest. You have adopted procedures that prohibit this already. It's in your Conflict of Interest Code that you all review every 2 years, applies to council members, staff, and many mid-level staff as well. And it incorporates the state law prohibitions here that the statute requires. Next slide. So the town has adopted procedures for professional and special services. These are in another section of the code section I mentioned at the beginning here. All of the contracting procedures are in chapter 3.32. 3.32.500 is specific for professional and special services. These procedures do not apply to supplies and equipment, general services, or public works. So if you're reviewing a contract and you're thinking, this doesn't look like the procedures in 3.32.500, that's likely because, or that is because, it doesn't apply, right? You have to look at what the town is contracting for to determine what procedures are going to be followed. Next slide. So here's what 3.32.500 says. If you are contracting for professional services, these contracts should only be awarded to firms or persons who have demonstrated an adequate level of experience, competence, staffing, other professional qualifications necessary for more than a satisfactory performance of the services required. Once the department requesting the service has determined this, the cost of the service may be considered. This is a state law requirement too. So the very first thing that town staff is considering is, are these people qualified? Do they have the competence? Do they have the work history to do this? Then we will consider the cost as the next. Town can use RFP for this process, and sometimes does, but state law and the municipal code does not require an RFP. So the fact that the town has not gone through an RFP when selecting professional services is allowed not only under state law, but also under your municipal code. Town staff follows this process. Next slide. So and this is just a restatement of what I just said, you can acquire professional services through a negotiated contract. That's how it's procured. Shall be procured through a negotiated contract. It can include an RFP and RFQ, and staff sometimes does so. And if the council ever directed us to do so, we certainly would. They're not required to be competitively bid, let to the lowest bidder, or procured through use of an RFP or an RFQ. So when you hear, well, you contracted for professional services, but you didn't go out to bid and you didn't select the lowest bidder, that's because state law and the municipal code doesn't require that, and we have to factor in other considerations, which we've done. The town manager approves contracts up to and including $45,000, and the town council approves contracts above that amount. So when you're looking at your agendas here for your twice monthly meetings, you will see contracts in the first instance where the dollar amount is over $45,000. And if there is an existing contract where an amendment pushes it over that amount, that is also placed on your agenda for approval. And that's because that is the limit of what the town council has delegated to town staff. And so we're always monitoring those dollar amounts, and if we get to that level, we come to you and place it on an agenda for your consideration. Next slide. Moving now to public works. This is our last category and a different type of contracting procedure altogether. The town is subject to the Uniform Public Construction Cost Accounting Act, which has a very long and somewhat unuseful acronym there. But that is the acronym for the act. It is a procedure in the Public Contract Code. So there is a entire state code. So when you're looking at state statutes, they're divided into codes, right? The government code, the civil code, the penal code, all of these codes contain laws that relate to those topics. There's an entire state code called the Public Contract Code, and it only relates to how public agencies contract, state agencies, local agencies, including the town. The default procedure in state law is that cities, which includes the town, of course, follow a very low prescribed process for bidding that would require that everything be competitively bid. The threshold is $5,000, and I'm not aware of any construction project that can be done for less than that, although John might correct me. So that would require competitively bidding for everything, right? The default procedure. So the town, like just about every other city and special district and county, many of them, I'm going to say almost every other, it's most of them, have adopted the Uniform Public Construction Cost Accounting Act. The law, once you become subject to it, provides a tiered solicitation competitive process. It allows up to $75,000 for purchase order or direct contracting, $75,000 to $220,000 as informal bidding, which we'll talk about in a moment, and then over $225,000 is competitive bidding. This is what's referred to as design, bid, build. So when you hear what's the difference between design, build, that's a separate process, and design, bid, build, traditional contracting for public works is design, bid, build. The reason for this is that it requires a separation of functions between the people who design a project and the people who build a project. This separation of functions was put in place to prevent some gamesmanship that might occur between people who design a project and also build the project. Design build is nevertheless allowed under very limited circumstances. You have to adopt a resolution. You have to become subject to your own conflict of interest code to prevent some of that, all of which the town did last year. And we spent a lot of time discussing that, so I won't go into more detail on that. But this is design, bid, build. It applies to quote-unquote public projects. And this is why public projects and public works are sometimes referred to interchangeably. The act here refers to public projects. So this applies to construction, reconstruction, erection, alteration, renovation, improvement, demolition, installation, and repair work involving any publicly owned, leased, or operated facility. So when the town is doing one of those things, including painting or repainting, we are following the state law, Uniform Public Construction Cost Accounting Act. Next slide. It does not apply to maintenance work. Maintenance work, routine, recurring, usual work for the preservation or protection of any publicly owned or operated facility, landscape maintenance, work performed to keep and operate a publicly owned water, power, or wastewater disposal systems, like what the town has, resurfacing of streets and highways, but it can be only up to 1 inch of resurfacing. If it's more than 1 inch, then we do have to go through the process. And then minor repainting, and minor repainting is something less than major repainting. So these are the exceptions. So if we're dealing with maintenance work, we're still contracting, but it's going to be under general services, likely. That's the process we talked about earlier. And so we're still following a process. We're just not following the Uniform Public Construction Cost Accounting Act. And next slide. So there are 3 levels of procurement. I mentioned those briefly. There's restated here. Contracts of $75,000 or less, the town can go out and select a contractor. There's no competitive bidding. The town manager has been delegated that authority by the town council. Contracts of $220,000 or less, and I misquoted earlier, it's $220, not $225. This requires informal bidding, and it is approved by the town council. So to unpack informal bidding, every year the town publishes a solicitation in trade journals and also in the Napa Valley Register for contractors to be placed on the informal bid list. The informal bid list is then compiled with certain contractors that specialize in certain things. And that list is updated every year as the town goes through that process of updating it. So that is widely solicited. Contractors apply and they're put on the list. When the town has a contract of $220,000 or less, it sends out a bid solicitation to the folks on the informal bid list. So the folks who have been pre-qualified through that process, they are sent it. The town also sends it to anyone else who might be interested, not just people on the list, but it is sent to the list. And then those folks have a chance to respond to bid on that project. But it is a more streamlined process because you already have a pre-qualified list. You're sending out your solicitation to that list and to others that you know who might be interested. And there's a shorter window for the contractors to apply and to respond to that bid solicitation. Contracts more than $220,000 go through a complete formal bid process. And that requires publication in the Napa Valley Register, a longer period for folks to respond, and then a sealed bid opening. And so those bids will be received under seal by the clerk. The clerk receives the bids and holds them in trust. And then there's a bid opening that occurs usually in this room at the same time so that everybody can watch. And then the bids are determined whether they are the lowest responsible bidder. And there's a process for that. Next slide. So if informal or formal bidding applies, the town must award the contract to the lowest responsible bidder. And I think this is where some of the confusion comes between these types of contracts and other types of contracts. So this concept of the lowest responsible bidder, it does exist, but it applies to public works and public projects and not to professional services. So some folks might incorrectly believe you always have to pick the lowest responsible bidder. That is not the case. If you are contracting for public works, that is the case. So next slide. A responsive bidder is someone who has responded to everything that the bid solicitation asks for. And so John and Rosalba and their team, they put together a bid solicitation that will have very specific requirements. You have to submit all of this information, what your dollar bid is for each of these items, who all of your subcontractors are, et cetera, right? So if somebody submits a bid and leaves some of that information out, they're typically not responsive unless there's some exception in the law. Sometimes they can be disregarded, but often not. A bid can be responsive even if there's a discrepancy in the bid, as long as the discrepancy is inconsequential. So in other words, if somebody forgets to or miswrites the date, right, or omits some technical information, as long as that information doesn't go to affecting the amount of the bid, give the bidder an advantage, create a potential vehicle for favoritism, influence potential bidders, or affect the ability to make bid comparisons, it might be able to be waived. So if you get a non-responsive, staff will reach out and we will look at it and decide, is this something can be waived or is this person non-responsive? The purpose here is that, before these laws went into effect, there was a lot of cronyism and pay-to-play that was happening between public projects and contractors in the community. The purpose of this is to give all contractors a fair opportunity to bid, regardless of who they know and regardless of those contacts. So the town has to award it to the lowest responsible bidder when that bid is opened. And so it's to prevent some of the more unseemly things that used to occur. Next slide. A responsible bidder is someone who can perform the contract based on the bidder's trustworthiness, quality, fitness, capacity, and experience. These factors include performance history, financial information, bonding and insurance capacity, public works experience, personnel, litigation history, and professional licenses. So in other words, you might get a responsive bid, but then you find out that the contractor has a suspended license with the Contractor State Licensing Board, or doesn't have the financial ability to execute the bonds for the project, for example, right? And so that would go to responsibility, not to responsiveness. So we are looking at those two pieces every time we're contracting for a public works project. Next slide. So if no bids are received, and sometimes that does happen, the town will go out to bid and nobody responds, right? If that happens, the project can be performed by force account, where the town does it with its own forces. That doesn't happen very often in Yountville, but there are agencies that choose to do it with their own forces. Or you can go out and negotiate a contract to have the work completed. If after receiving bids, you determine that you can perform the work more economically on your own with your own forces, you can reject all the bids and adopt a resolution by a 4/5 vote declaring that. That doesn't happen very often, but it is a process that's available. Emergency contracting is also allowed for public works. It has to be sudden, unexpected, and affect health and safety. So think about like a water main burst, a sewer line has broken, an earthquake, a roof is collapsed and is about to fall and is a real hazard. It can't just be something that you haven't really planned for. And if you are aware of the possibility of this happening over time, then it's not sudden and unexpected. So this is not a way to get around the contracting procedures. It's a way to ensure that the community is safe when something dangerous happens. And so it's not used very often, but it is used occasionally. The town must comply with the Commission's Cost Accounting Policies and Procedures Manual. There is a Uniform Public Construction Cost Accounting Commission. The commission lives in the State Controller's office. That commission adopts a policy manual and also hears complaints and can suspend local agencies from using this law when you don't follow it correctly. And that commission does oversee all the agencies that are using this process. But they have a cost accounting policies and procedures manual that gives very specific detail on how things are accounted for and how you price things. For example, you might have a public works projects that has $120,000 in equipment and then $80,000 in services that pushes you just barely into the next bidding threshold. And some agencies will bid that informally, even though it's over the threshold and should have been bid formally, for example. So those types of things will go to the commission. But the Cost Accounting Policies and Procedures Manual goes into a lot of detail on how you account for that and how you follow those procedures. And so town follows that as well. Next slide.
Gary, what is, when you say it can be performed by a force account, what is that?
Town staff.
I was wondering. Okay.
Yeah, that's the term used in state law, but it's town staff. So you can go out and do it.
Forcing them to work.
Why?
Yeah.
Why
Well, as long as they want to work it. Yeah.
Why would we, in some case, well, not to belabor it, but why would we not have started with that in-house before going out to bid?
Well, so this law says you have to go through this bid process before you can do that.
Wow.
if it's within these dollar amounts, right? So if you are within up to and including 75,000, you can always do it by force account. You can just go and have your town staff go and do it. If it's 75 to 220 or above 220, the town has to go through this bid process, and then at the end of it conclude, we can still do it cheaper, basically. We can do it for less.
Force you to spend
Right.
money.
Yeah, so the policy of the state is to require you to look at all these bids first for those dollar amounts to make sure, are we sure that we can do this in a more cost-effective way? So it does require more process and contracts. But yes, you can still do it on your own, but you have to go through the bid process first before you can get to that point. Yeah. Next slide. So there are different types of procurement for public works out there. So what I just told you about for public works under that act, that's the general default that the town follows. But there are alternatives in state law. Those alternatives include design build, something I think we're all quite familiar with here. The state has limited design build to projects over $1 million. So they want to make sure you're only using it for a larger project. You have to adopt a resolution, and you also have to adopt a conflict of interest policy, all of which the town did last year for its proposed use of design build. That resolution remains in effect, so you could continue to use design build if you were to follow everything in that resolution. Design build, as the town was using it last year, requires that the town come up with a set of preliminary plans. So that is why the town hired an architect to come up with a set of preliminary plans, and that was Kelly Morgan who came up with those. Those preliminary plans are then used in the design build process, and the design build entity is a single entity that finishes the design and constructs the project. But they finish the design that was done by the preliminary designers. That is exactly how design build is designed to work. The town contracts for preliminary designs, and then those preliminary designs are finished, and the project is constructed by a single company. There are strict procedures that have to be followed. The town followed all of those for design build. Progressive design build, which is another type of design build, is a slightly different process. Progressive design build is where you bring the design build entity on at the very beginning without doing a set of preliminary plans. And under progressive design build, that design build entity works with the town throughout the process to do the entire design and build it. One of the downsides, I suppose, to use that phrase with progressive design build, is that the cost is even more uncertain. Right, so the downside and why some agencies don't use progressive design build is how do you enter into a contract at the get-go when you don't know, you don't have any design, right? You don't have any idea of how complicated it will be or the construction costs that will come later. But progressive design build is used by some entities, and it is another process that's available, although town chose design build last year, but there is progressive design build, so I just want to mention that.
That if you had already done a project very similar, it seems like maybe you're bringing in people that
could be
that already have a full understanding of
yes
what was built next door and
that's right.
Maybe you built
Yes.
the project themselves.
Yes, and under progressive design build, you don't have a hard cost until sort of mid-contract, which makes it difficult to administer too and to budget for it. So, energy conservation contracts. This is another exception to the traditional bidding and contracting provision. So the town can contract with a single entity to design, construct, or install an energy savings or energy conservation contract. So this could be a solar project. This could be a upgrade to more efficient lighting or AC or cooling, heat pumps, things like this. And you can hire a single company to design and install it. And there are companies that do that. And that's another exception to the traditional process. If you follow the process in the statute for energy conservation contracts, you would not be going through an informal or formal bid. You would follow that process. And next slide. All right. That was a whole lot of information. I will pause there. If you have any questions, I
think it's very, very valuable information, and because, some of the comments, I've heard too from, the public when, I can't describe it in the detail you did, but, I certainly know there's different categories here. And they say, well, you should still, go out for a bid anyway. It's just a good process. But it isn't really a good process necessarily. It's not like, you can skip some steps because the law says you can. It's sometimes going out for the lowest bid isn't, necessarily the best for your particular project. So I think those things are difficult and to go through this. And it's really great that you have to sign off on all these contracts, right? So you are, the buck stops with you. Like, did they go through the right procedure, and was it followed?
Yeah, I should note that. So the process is town staff will often consult before they start a process. So we'll talk about it at the beginning. And then once a provider is selected, there is a set of form contracts. I update those form contracts once a year, much to the chagrin of staff, but I do update them once a year. We look at changes in state law and make sure that the agreements are up to date. And so some years there are quite a few changes, some years there are not many changes, but we do take a look. And then we also learn, right? So if there are disputes that come up with consultants over particular provisions, we will make them better over time. And so there are form contracts that are used for each of these different types of things. So there's a contract for services, there's a contract for maintenance, there's a contract for public works, there's a contract for design professionals because they have special requirements under state law. Those contracts then are routed for signature. I sign it, town manager signs it, clerk also looks at it, the department head looks at it, and then it goes through that whole process. And yes, we absolutely inquire about the process, and if it's a service that should have been categorized differently, we do use the different contract and we restart and go through a different process. And I know Public Works could give you an earful about our feedback on that if you ever asked them.
So one other question, one of the things that was kind of unique to the town last year was, or the year before that, public-private partnerships. We really hadn't done a lot of those. So, and those really don't fall into any of these categories at all. So those are a little more flexible in terms of, what the partnership wants to do and what we want to do, and those are negotiated differently. Is there any kind of general rules that would apply to those without?
Well, yeah, I'll speak generally. So those take on a few different forms. It can often be about funding. It can sometimes be about the town owning a parcel and being the owner and wanting to bring in a private person to fund it in whole or in part, or to build it in whole or in part. So if the town is providing land or providing funding but not undertaking the project itself, we wouldn't be following this process, right? You could enter into a contract that says town will contribute X amount of money in this land and private folks will come in and build, right? So we wouldn't be dealing with these types of contracting because the private entity would be the one doing the building, not the town. Providing public funds to a project does trigger prevailing wage for the whole project.
For the whole project?
Yeah, so there are things that would change for a private person if you are contributing funds or public resources to it, but that's a different process, and those types of agreements take on lots of different forms, but it's usually some sort of funding or property owned by the public agency.
And it's at the discretion of the council to do that if we want to as a public benefit.
That's right.
Okay, great, thanks. Any other questions, Councilmember Tripp?
Yeah, I just wanted to make a comment on the, and the slides don't have number, but the professional services contract slide, it's professional services continued.
Bottom right.
Yeah, so the second bullet, and you point out, and I do understand this, that professional services contracts are not required to be competitively. This has been a great presentation. I'm going to save it, but this is the only area that I really have any questions about, and it's also the area that has caused more discussion. And I don't want to go into a long thing at this time of the day, but for example, when I worked at the University of California, which has a kind of strange, they're public but not, we would bid, my department, I was responsible contracts for several $1 million for administrators of employment claims. So these are people who would see all the details, had to pay all the lawyers, were involved in all the meetings, clearly professional services. The regents felt very strongly that those contracts over a certain amount we should consider a professional, at least 3 proposals. These were worth several $1 million a year. Yep. We were signing them for 5 years. Didn't have to pick the lowest bidder, but they wanted us to publicly have requests for proposals, in part because they wanted us to get the best service provider, but it also communicated to the industry that we weren't playing favorites by considering various proposals. And when I raised this with you not too long ago, you indicated that probably informally we were looking at various proposals for professional services, such as architects and the like. And just because we didn't go through a process, I shouldn't assume we weren't doing it. And at the time I asked you whether there could be any sort of town policy that professional service agreements over a certain amount, and we have entered into some that are, close to $1 million when all is said and done. If we could not have a policy that those contracts should, we don't have to pick the lowest bidder, but we should look at different proposals, which in fact happens, like when you were selected. And you said at the time to me, we would probably be one of the only towns or cities that does that. And actually, I've investigated it, and there are other towns that have that.
There are. Yep.
For the same reasons that the UC did, which is you want to be sure the industry, the other people in that business know that we're not just picking people. So I just want to ask you again, could we have a policy that a professional services agreement over $250,000, over $100,000 would require not the lowest bidder, but a review of competing proposals? Could we not have that policy?
Of course, yeah. The only restriction on use of that or non-use of that is in your municipal code, and this council can always amend the municipal code. So
or could we? Oh, we'd have to do it via the municipal code.
Yes.
Okay.
So you would need to adopt an ordinance that changes how the town contracts for professional services, but that is within the discretion of the council.
Right. And the only other thing I would like to say is that the legal standard it is the bottom of where we can go, but not necessarily the top in terms of due diligence. And I just, not to beat the dead horse, but when we approved in June, and this is all on tape, last June, a group of contracts that was over $2 million, we did not have complete information at the time. It was a legal approval, but some of the contracts did not have, and this was for professional services, detailed information in the exhibits on what we were going to pay people per hour and the like. And your comment at the time was probably best practices is for the council to be able to see that. Mm-hmm. And I would just like to reiterate that, and at the time I said this, and please go back and look if you don't believe me, I think we should be approving in all instances contracts that are completely, I know it was legal what we did, but show all the rates, show all the exhibits, a complete contract. So would that need to be a policy, or would that have to be in the ordinance?
I don't think it has to be in the ordinance. That could be direction that you give, that the council gives to staff on how you want to see these contracts coming on the agenda. I don't think that doesn't need to be in the municipal code. Unless you wanted to. You could put it in the municipal code. Yeah, and I stand by that comment. I think when agenda items are in front of you, I think understanding and having a full picture is always a good idea.
Right. It's part of the oversight, even if not legally required, at least in my view.
Right.
So I would like to suggest at some point maybe we consider giving that direction.
Right. Yeah, the only comment...
It has caused some, and then I'll stop. It has caused some issues subsequently, and it's really hard to approve a contract if you can't see exactly what you're going to be paying the people per hour. Not that we would probably disagree, but it's part of our oversight.
Yeah. The only comment I would add on requiring an RFP process for special services above a certain dollar amount is that quite often the town will hire a consultant to do work. And let's say it might be, $100,000 to redo or to do an addendum for CEQA, or maybe $200,000 to do an addendum for CEQA. And then midway through that, the project changes pretty significantly. So you might have a change in the scope, or maybe there's 2 additional studies that need to be done, and the like. And so that is what triggers the amendment. And so when you all see amendments here, it's because something has changed on the ground. Project has changed, there's a new study, and the consultant is saying, okay, in order to do that, here's what it's going to cost and the additional time and scope of work. That could push it above the threshold you create. And so we need to think through how that would work if you are putting a dollar in there. I wouldn't recommend cutting ties with the consultant and restarting the process over, and so we probably need some way to address that.
And I do think that could be addressed, certainly, because of what you're saying. And if it is such a major change of scope, then that would require a significant expenditure, then that kind of relates back to the question, what were we thinking when we went into it? What were they telling us about what could be done or needed to be done? So I wouldn't want to throw the baby out with the bathwater, because there could be some wrinkles to this. The basic thrust being we should look at we should look at a variety of proposals for professional services that exceed certain amounts in total.
But, I do have a concern about, as a consultant myself, sometimes people will say, I want project X and this is what it needs done. Do you bid it by the hour or do you bid it by the project? And I'll, tell them that typically I like to, bid by the hour. That way, if you do need any amendments or anything, then you know the hourly rate. On the other hand, they say, well, we would just like, for the fixed amount. So I can do that too. So I think it really kind of depends on lots of things, the end user and what you're really doing. And anyway, so I think there's a lot of complexities to how you really want to go about that too. There isn't just a fixed way. So, yeah, Vice Mayor.
I also want to add just a comment about, it's been brought up a number of times today, the Kelly Morgan contract. And it wasn't just one thing that we were contracting with them for. And the council did see each step of additional funding meant for each part of the project, like the barbecue area, the painting, and the modeling, and the design documents, and all of those things.
Public outreach costs us a lot too.
Yeah, public outreach. All of those things were like an a la carte menu that we approved at each step. So it's not that we overran, but we might have chosen to give it to someone else, but it was better to have one person be in charge of the design criteria and all of that stuff. So some of the concern that's being expressed is not, I don't think, valid for that idea of we need more oversight. We had oversight, and we did use that oversight to agree with the consultant and with the town manager about what was the next step. So I feel like that's a little bit of misplaced kind of oversight. Yeah.
I guess I would just ask the council member, I wasn't arguing that at each step as it proceeded. I was just saying when we started, we did not have any, at least as I'm aware of, with that particular, I wasn't just speaking about that contract, any I don't want to say competing because it's not about price, but of varied options of different people who could provide those services. Eventually, as it all crept along, you're right, we went ahead and approved it, but that was what I was suggesting, that when we're embarking on something that we surely knew in hiring, for example, that architect, we were going to spend a considerable amount of money, and looking at varied options for those types of professional services agreements is all that I'm suggesting.
May I please ask, where does the do not exceed fit into that? Because that was kind of the guardrail as I understood it. And then another kind of a separate question. We know that the threshold for the town manager is 45,000, and there's a lot of doubt being sown that he contracted for 44,900, and knowing full well that a contract was going to go over that part. My understanding is those increases to the expenses came before council, so we could review and vote on those. But as we're looking for what possibly could be tightened up in the future, is there any room for us to kind of safeguard that?
Yeah, well, my high-level comment is it's not a violation of the law to follow the law. So if the town manager is contracting within his delegated authority, that's allowed. He's been delegated that authority. So I don't think there's anything improper about contracting within what the municipal code says he can contract within. Entering into those contracts, it can sometimes be a matter of expediency. It can sometimes be because there's a change of scope that's coming, right? So, for example, the town might need those services this week, but you council members will only meet twice a month, right? So there might be reasons why the town manager needs to contract quickly within that contract authority. And then if it does go over, it always comes to you all, of course. So that process was followed for all of these contracts.
Thank you for pointing that out.
Yep.
Okay. And then the do not exceed was the kind of the end picture of where these contracts that maybe we didn't get to see the hourly rates and all the details that all of us wanted, but the do not exceed was still within the budget.
Yes.
Yeah.
Yeah, I should note that there's a separate question here, which is, did the town council budget for these things, right?
Yeah.
And so there's a budget document that includes appropriations for each department and funding. And so that is, Celia's always tracking that, and her team, Celia and Kyle, and they're walking through that, making sure that that's being done. And if needed, they will come with a budget adjustment. And that's why sometimes when contracts come to you, it's not only approval of the contract, but also a budget adjustment at the same time. If there's no budget adjustment, it's because it's already been approved and budgeted for. On the not to exceed amount, every contract has a not to exceed amount, every one of them. And that is the maximum unless and until there is an amendment to it.
Okay.
And so the contractor can't go over that amount that's in there. It just won't, they won't be paid if they go over that without an amendment.
Thank you.
Public comment? Okay, good. We've got some takers. All right. Come on up, Alan.
Yeah, I only needed to stand up. Alan Tencher. Thank you for this really informative discussion, and thank you for a job well done. I think I understand the process a lot better. I don't know if I really can offer a lot of insight into when you hire somebody, whether you should look at 3 of them and whether that really helps or not. Maybe not. But I think the important thing is that we have procedures, and if you all collectively feel that we should amend our procedures, then perhaps you consider that. But more importantly to me, you struggled here with whether to actually even have this discussion tonight, and I know it cost you probably sleep later on, but it was noticed. It was noticed, and I think that's all that really needs to be said. We all make decisions on how we spend our time, and we chose to spend it here completing this important task. So thank you for persevering and making sure that this is now part of the public record. So thank you.
Right. Thank you, Alan. Ashley, please.
Short, Ashley Tencher. In my work with NVTA, they are also discretionary authorities on spending limits, and they're reported with periodicity back. So I just propose maybe the public, do we have a reporting way of seeing what the town manager approves up to 45K on a quarterly basis? Perhaps Celia's already doing this, but if it were shortlisted, it also might just really help the transparency issue. If we could just sort of see it, maybe in a consent calendar, just listed, we see what it was. Because I heard the ED of NVTA just comment on that. I'm completely accountable for my choices of my discretionary authority. And that's actually exactly what's going on here. And maybe the public would just like some reassurance in that. Thank you.
That's a good suggestion. Thank you very much for that. Any other final comments, Councilmember Knight?
Just quickly, I do appreciate this discussion, and thank you, Town Attorney Bell. And I think,